This is Nicholas Peterson, and my presentation is on bullying and schools. Some of the background for this legal issue would be the situation originated when a female student sent a nude picture of herself to a male student. There is no conclusive evidence to determine if the female student voluntarily sent the image, if the male student asked her to send the image, or if there was pressure to send the image. The male student shared the image with a group of other students. The female student started hearing groups of other students talking about her with sexually explicit content. The female chose to end the relationship, but the same group of students started demoralizing her and purposefully excluding her from everyday things at school. The students continued to make fun of the female student by making comments on online social media chats and changing their statuses to include demoralizing content about the female student. After this was brought to the attention of the administrator, the female student started receiving hate mail for causing the group of the students to get in trouble. There were other verbal comments made during classes from the group of students that caused fear for anyone else to speak out against the group. Students felt that they were threatened emotionally and did not feel safe to speak up. Teachers intervened to let the surrounding students and the victim know that they were safe from any repercussions from the aggressors. Some of the most prominent violations of law would be a violation of the South Carolina Safe Schools Climate Act, where the schools are there to help or within the schools, they need to prevent school harassment, intimidation, and or bullying. A potential threat to this could be, since the teachers act in loco parentis, that the students are in their charge while at school and, quote, allowing this behavior to continue. Also, if this issue is not addressed, the school can then be held liable for negligence. Bullying is defined as a gesture in electronic communication or written, verbal, physical, or sexual act that is reasonably perceived to have the effect of harming a student physically or emotionally, or damaging a student's property, or placing a student in reasonable fear of personal harm or property damage, or insulting or demeaning a student or a group of students, causing substantial disruption in or substantial interference with the orderly operation of the school, as cited directly in the lecture covering cyberbullying. One potential violation could be the First Amendment rights of the accused bullies, and they're violating their freedom of speech. We can look at the case Tinker versus Des Moines Independent Community School District, where the ruling said that there could be a substantial or material disruption in the learning, and that this could interfere with the educational process or school discipline. They can utilize school-owned technology to harass or threaten other students or infringe on their civil rights. That was where Tinker had posted about wearing the black armbands at school in protest, but in this case referring to the infliction of mental or emotional distress, and therefore also potentially a civil lawsuit for either assaulting or the defamation of character, both in libel and slander forms of the female student. The Kowalski and Berkeley County schools, where a student was suspended for creating a hate website that targeted another student. The suspended student then sued the school district, alleging that it had infringed upon her First Amendment free speech rights. The court held that the speech created actual or reasonably foreseeable substantial disorder and disruption, and the school was therefore not the type of speech. The disruption happened at school and was therefore not a type of speech that merited the First Amendment protection. This type of conduct in this school case or potential case says that the conduct substantially interfered with the requirements of appropriate discipline in the operation of the school. The conduct that is considered disruptive, foreseeably disruptive, and that there was a, quote, true threat, and therefore does not fall under or be protected within the First Amendment rights. The school policies directly relate to this issue in saying that the access to, quoting the handbook, access to the district network and internet is made available to students for educational and district operational purposes. Students will receive instruction on proper use of district's network and internet system. The district will not be liable for students' inappropriate use of the district's electronic communication resources or violations of copyright restrictions, users making mistakes or negligence, or cost incurring by users. The district will not be responsible for ensuring the accuracy or usability of any information found on the internet. The schools should be a safe place where the students would be able to come to school and not have to worry about the potential of threat of being a victim. In the Zano versus Pine Plains Central School District, the court ruled that the school did not do enough and was deliberately indifferent in its response, which led to continued harassment. What educators could take away from this ruling is that once they learn of such victimization taking place, they have a duty to do everything in their power to ensure that it stops. Simply disciplining the student who did the bullying is not enough. That we must ensure that it actually stops and the person targeted is then safe. Responses to bullying need to be targeted, focusing on the nature of the harassment, comprehensive, so that the long-term reoccurring programming versus the one-time brief presentation and the effect that the bullying has stopped or is at least significantly reduced. Due diligence involves more than just applying the immediate response. It would then require the response moves the behaviors in the desired direction. How are we going to stop bullying? There are statutes set up in the South Carolina Safe Schools Climate Act that directly state that we should set up specific definitions of harassment, intimidation, and bullying, including the electronic variants. graduated consequences and remedial actions, procedures for reporting, procedures for investigating, language specifying that if a student's off-campus speech or behavior results in substantial disruption in the learning environment or infringes on the rights of other students, the student can be disciplined. Procedures for preventing cyberbullying should also be addressed. As a school, we need to focus on building a character development plan with an emphasis on anti-bullying. The mission statement could be a superhero. We also can report or create an online tip form where students can anonymously submit an issue without fear of repercussions. Some of the legal resources that were used in this presentation were the South Carolina Safe Schools Climate Act, Miller v. Mitchell, Tinker v. Des Moines, Kowalski v. Berkeley County Schools for the different legal aspects presented in this case.